So welcome everybody. This afternoon, we have attorney Seth Schwartz here to present to us on navigating your special education rights. I know there's a lot of questions that have come up, especially around this pandemic timing of, what are our rights? How have things changed? And I will tell you, I've leaned into Seth quite a lot to get the answer. So I'm really happy to bring him here to you today. He is the founder of Brightside Law Group and has been just a wonderful resource for our community. So Seth, I will let you take it from here and I'll just kind of pepper in questions as we go.
Awesome. Thank you, Megan. Thank you for having me in La Jolla Learning Works. And, this presentation is navigating your special education rights. And before we get started, I just want to remind everybody that the information that you get today is not legal advice. It's not direction on any particular concern. I always try to remind people that your kids are very different from other kids, even if they have the same disability. And what works as a methodology in reaching that child is going to often differ by the students. So, just keep in mind if you're having a concern or a problem, you should really reach out to an advocate or an attorney in our field and get some specific information or an opinion on the concerns that you're having and not rely specifically on the information you're getting here. This is meant as a primer or a direction so that you can go and do searches and understand the area of special education law just a little bit better. My name is Seth Schwartz. I'm with Brightside Law Group. I'm the managing attorney here. We do special education and limited conservatorships. We offer free consultations. And if you have a special education matter, we often can represent you at no charge directly to you. And we're always available to answer questions. We have a very open door policy. As Megan mentioned, she's come and asked a question here and there. But we are open for families. If you have to come back 10 times and never have a case, we're just happy that we can provide some help and you can get the answers that you need. So we had an opening question that I thought was a good place to get started. How has special education law changed as a result of the pandemic? And initially, the biggest change was that assessment plans for students that had not been assessed yet were essentially suspended. It wasn't required to go and get consent for those assessment plans. But of course, in July 2020, the law that had passed to say that actually lapsed and it was no longer valid. So assessment plans were back in play. That was in California, though. It didn't abrogate the federal law to provide assessment plans during that period of time. And if you had signed an assessment plan prior to the pandemic, they were still required to provide that at a meeting within 60 days of your signed consent. In mid-2020, they had a requirement for an emergency plan to be added to the IEP. If you live in California, you've probably seen this emergency plan. It's usually 1 or 2 pages. And it basically says if schools close down for more than 10 days, how are they going to address the student's IEP in the home environment? That is still an existing legal requirement. And then distance learning requirements had passed, which discussed the different hours of synchronous or asynchronous learning that had to be in place for a student during their school day. But as we got to the end of the 2020-2021 school year, that actually stopped as well. It sunsetted is the legal term for that, and distance learning went to what we would refer to as an independent study or virtual school option, which I'll discuss in just a second. Schools began to reopen in hybrid and in-person learning, and by April of 2021, the state actually incentivized the reopening of schools. So many schools opened for that last semester for 4 to 8 weeks, depending on the school district and their capacity to sort of turn around and open those schools up. But as we get into the 21-22 school year, the law has changed to say that there needs to be an independent study option. And part of the reason for that is independent study had already existed. Distance learning was something that we did for the pandemic, and they were looking for a way most likely to count attendance and other things that were going on. So the independent study language sort of gets in the way with special education because there is a pre-existing statute that requires independent study to be vetted out by an IEP team and determine whether or not the student can actually effectively participate in independent study. So a lot of students are finding that when they would like to take an online or a virtual option, that the independent study is not appropriate for them based on the IEP team decision, and the only option is in-person learning. If you have that situation where you're thinking, I really don't want to go back in person because I have concerns about health and safety, you should start by talking to the IEP team. And then at some point, if you feel like you're stuck, speak to an attorney in the field and get some specific information about your facts and circumstances. Of course, now we're seeing a lot about health masks and vaccines. It looks like the states required vaccines, and as they become available to the younger kids, schools are probably going to be requiring those, and they are requiring those for teachers and staff that can get them. Masks are still a big open question. Masks are required in school. The CDE has given us some guidance that says students that can't wear a mask can wear a face shield with a catch at the bottom. And health and safety is left largely up to schools and policies and procedures. When we're dealing with health safety, masks and vaccines, you really need to talk to the school. Masks, of course, you can accommodate or you can work on wearing a mask with a student, but it shouldn't be the exclusion of that student from school just because they can't wear the mask. Vaccines is a more complicated issue, and if you're sort of facing that question, or maybe your child isn't vaccinated now, you should really speak with an attorney about that to determine what your options are at that point. But always be aware of the health and safety measures that the school is doing, and you want to talk to them about it at an IEP meeting and any specific concerns that you might have about your child so that they can take steps to protect your child as well. So the way I like to think of special education as a framework, I like to think about it in terms of driving a car. When you get into your car, you know to stop at a red light, slow down through a yellow light, go through a green light. Don't cross those double yellow lines. Don't go too fast or you'll get a ticket. And when we think of special education in that framework, there's a similar way of thinking about it. When parent has a complaint about an IEP, it's usually in one of the three categories of planning, procedure, or implementation. Planning is that development of the IEP itself. Procedure is following the rules that protect that planning process, like holding meetings within a specific period of time, carrying out assessments so that they're available at those meetings. And implementation is the actual physical carrying out of that IEP, because we've done this great plan and we expect it to be done so that we can see the progress that we were trying to accomplish. And the policy under the law is access to education. We're looking for that student to be able to do what they are able to do, what we reasonably think they can accomplish within a period of time, which I'll discuss in just a moment. And how are things different with online learning? Well, when the federal guidance came out in roughly March of 2020, they said that we need to implement these IEPs to the greatest extent possible. And I'll talk about that in a minute as well, because I'm going to kind of go over this concept as we go down the road. Well, with schools in person again, the question about what it means to implement as the greatest extent possible is really a question about carrying out the IEP in the virtual world, which does mean that they needed to do the minutes and the therapies, the related services, if you will, in that virtual setting, unless it really wasn't possible. But we haven't seen a case that has really addressed a situation where it wasn't possible. Now, there's questions about effectiveness, and parents should seek somebody to talk about, if the student couldn't access that virtual learning and they had some unique circumstances. The question then becomes one about, did the school make good faith efforts to work with the family to try to solve these problems? Those are sort of deeper level sort of questions about the services the student received during COVID, but they are very warranted questions if you're having, and you should speak with somebody.
Yeah, Seth, that's what I was gonna, can I pause you for a sec? I was gonna ask you about that, and just to, I think there's probably a lot of parents that have that question of, maybe things were provided in some regard, during pandemic shutdowns, but it wasn't done, to any level of effectiveness that, was at least up to spec, or, for a parent could be comparable to what the student was getting in school. And is that something that is a valid case at this point, or could be a valid case and a reason to connect with an attorney?
Yes. So if it's a straight implementation problem, the school just didn't provide service or provided less than the whole service is expected. Those are what we would call a material failure to implement. And those are compensable to some degree. It depends on the circumstances. But for the students that couldn't access and the school district was aware, and maybe they weren't meeting with the family to discuss these things, and the parents were saying, hey, my child can't do this. And then maybe school reopened for in San Diego phase one, and they wouldn't let the student back because maybe they didn't have the staffing they needed or something of that nature. Those kind of things sort of lend to the question about, did the problems occurring with the carrying out of the IEP, were they actually caused by the team versus, being at home and, everybody's doing their best, but we couldn't quite make it over the finish line. But generally speaking, the answer to your question is yes, but we're going to look at the facts and circumstances and try to understand how we got there. And when we get a little bit further along, we can talk a little bit about the types of things we're seeing now that we're a year and a half, almost 2 years into this, and what these situations are looking like in hindsight. Missed meetings, not providing services, not working on goals, and things of that nature.
Thank you.
So what is FAPE in the LRE? So FAPE is free appropriate public education and LRE is least restrictive environment, but sort of the nuts and bolts of that is, FAPE is what we're going to do and LRE is where we're going to do it. When you look at an IEP, when we're talking about planning, FAPE is a reference to that plan. The FAPE is what we're going to do on that plan. And again, LRE is where we're going to do it. So I like to go backwards when I describe these things because, what you have as FAPE, the what we're going to do, drives the question about where we're going to do it. But LRE is really a question about educating our students that have disabilities with kids that don't have disabilities, think role models for our kids. And what the court said, or excuse me, the law says is that the maximum extent that is appropriate, we want to educate kids with disabilities with kids that don't have disabilities as until it can't be achieved satisfactorily, which is a lot of wishy-washy language to say that we have to find some measure in order to figure out how to apply this in practice. And what the courts say is that you don't have to try gen ed and try to keep the kids in what we would presume is the least restrictive environment. You have to look at that child and balance out some factors. And courts have said academics, non-academic benefits, and behaviors are the factors we're going to look at. And you'll notice on the slide we have cost, but no case that I have been able to find really addresses the question of cost as a reason that a district can say we need to go to a more restrictive environment. So academics would be how far behind is a student, what's their ability to access with the environmental factors that are going on in that classroom. Non-academics could be the other children in the class and things that might interfere with the social emotional well-being, and behaviors towards self, others, or the teacher is about distractions or things that might interfere. And if you go back to our policy, which is really access to education, we're asking the question about whether or not that student can be in that environment and make the progress that we anticipated when we designed the what of the IEP, the what are we going to do, what's appropriate. So when we look at what's appropriate, free means that it's not going to cost you anything. Public means that it's going to be taken care of and supervised by the public schools, but it could be a private program that they're monitoring. And education means that it deals with their education. So if it's only happening at home, but they're not seeing that in school, then that's going to be something that they don't necessarily need to address. But there are things that happen at home that could be school related. For instance, the inability to get out of bed and go to school because the student's depression is pretty intense, or behaviors that interfere with getting on the bus. Maybe the bus leaves after a certain amount of time because the behaviors got in the way and they just didn't have the patience, or they had to go to the next stop to get the next child. So those are the kind of things that can happen at home. Homework is a great example. It takes 6 hours to do a half an hour of homework. You're going to want to talk to the team about that, address ways to deal with that could be home-based in some extent, but they would have to deal with that problem. But the real situation really comes in with this word appropriate. And appropriate is a very subjective word. I always use the concept of autism. What I think for a child with autism is going to differ based on my impression of autism and that student's presentation of autism. And you or I may have very different impressions, but we're looking for a word that's going to be objective, and that's reasonable. And courts have actually used that word. They say that in order to be appropriate, the plan, this IEP that we're creating, it needs to be a reasonable calculation or a best guess that's going to confer, but not necessarily promise, because we don't know what's going to happen along the way. Some educational benefit, which I kind of look as a red herring, because educational benefit is a tough thing to measure. And based on what we know or what we should know at the time, we're not looking at hindsight at new information. We're looking at the decisions we made at that time based on what we knew. But we also should know things, which I'll come back to in a second. And we want to meet the unique needs of the student. And that's all of them. So if we have a reading deficit for age and grade, and we also have a math deficit, but parents are only concerned about reading, we don't ignore math. We have to address both pieces of that. And we look at 12 months of attainable progress. And so when you think about this a little bit differently, it's a reasonable calculation or a best guess based on information that we know. It's all the assessment reports, it's the progress reports, it's the new assessments that you might have from outside providers that could, give input to the team. And we're looking at things that we should know. So if we're scratching our head in an IEP meeting and nobody can answer the question about what level of reading is the student at, or why are they having these behaviors, those are all the new or should have known pieces, and that should have known triggers some procedural safeguards for the family because we suspect there's a disability or a need that's different, and we go out and assess, which actually, for that specific purpose of what we should know about, they can stop the planning as to that part at that meeting, and they can give the parent an assessment plan. They get 15 days. Parent gets 15 days to sign that assessment plan before the district can pursue, having those assessments done through a court. And then they have 60 days to actually carry out those assessments and come back to the IEP meeting and do this calculation, this reasonable calculation as to that new information, because now we know that information. So we have a reasonable calculation to confer, but not necessarily to promise some kind of educational benefit. And it's based on what we know or what we should know at the time. And we've got to meet the unique needs. 12 months is a reference to the annual IEP, and attainable progress has to do with our child. So we're looking for, what is our child capable of in a year? What do we reasonably believe they can accomplish? Because we're not going to set the goals so far ahead of them that they're not going to be able to meet them. A student who's making a half a year of progress a year, and we believe that, we're sort of pushing it at that, we're not going to shoot for a year because we know they're not going to make those goals. And if we do this sort of math problem correctly, we should have goals in multiple areas. They should be aligned to what that student is capable of achieving. And we should have all the information on the table, or we should go get it. And it's not a promise, it's a commitment to try to accomplish these things. Now, if we want to challenge the end result, certainly it's circumstantial evidence, is what we would call it, that the plan wasn't done right a year ago, we'll say. But we can also look at it from an implementation standard and say, well, we didn't meet that educational benefit because something happened and we didn't carry it out correctly. So similar to the new or should have known part, where we implicate these procedural things that happen at an IEP meeting, we can stop and come back to the planning later. The outcome of an IEP looks first at implementation, and then maybe we can go back and look at the time and see if we should have done something different on the information that we had back then. This is not an easy sort of conversation or thing to look up online. So I think it's important to know that this comes from a bunch of different cases. Rowley is one of the cases that sets up the reasonable calculation to confer some educational benefit. Andrew F., which is a more recent Supreme Court case, really deals with this unique needs of 12 months of attainable progress, but they don't write it that way. They write it as appropriate in light of the circumstances. I'm giving you some linguistics that might work a little better to understand how it works. And we are looking at the child. This is supposed to be individualized to the child's needs. And we're looking at what they can do, how they can progress, which I'm sure as we get to some of the questions later, we'll talk about attainable progress, especially when it comes to reading interventions, where we're looking at, can we get this child to grade level if they're 4 years behind? Or are they just making slow progress as we go? So I want to mention real quick that, in addition to this planning process, there are decisions that a school district or a local educational agency can make that are sort of outside of the IEP decision-making process. One of which is location of service. And if you think about this another way, a school district or an educational agency gets to run their business and pick and choose certain things that are within that sort of business planning without having to sort of negotiate that with anyone. And so location is one of those things. I've got school A, B, and C. A, B, and C can all do the job. They get to pick the school that they would provide those services for, as long as all of them can do the job the IEP set out to do. Of course, there are always exceptions to this. So if you feel like that's not the case, talk to an attorney or an advocate that can help you navigate this a little bit. Staffing is another piece. We can't control the staff. We can't be sure that staff will want to stay at their job. We can't be 100% sure that the staff that we have it can be allocated the way that we expect. And maybe, a school district plans an entire year of staffing and finds out on the first day they need to move everybody around. So things can get mixed up, and that's okay. And curriculum is its own thing. Schools have to go out and purchase it. They get to choose what they're going to teach. They have to train teachers on how to use that curriculum. So the courts don't say that a school district can't pick the curriculum, but there are exceptions to these rules. For instance, location that actually changes the situation. So if we have a student in a wheelchair and we have location A, B, and C, and C is not wheelchair accessible, but A and B are, then it has to be A or B. It doesn't meet the needs at placement C. Staffing is a little harder to do. You've probably heard a little bit about teachers' unions and teachers having a pretty secure position, even when things don't go quite right. So when we look at staffing, we look at what the staff is doing and are they implementing that IEP the way that they're supposed to. And often that winds up moving the student, unfortunately, not the staff member. Curriculum is its own tricky little piece. When we talked back about FAPE, we discussed a little bit about that attainability of a student. And if we have two curriculums, we'll say an Orton Gillingham based and maybe a Read 180, if we put them side by side and the student made the same progress on both, the school district would theoretically be able to pick Read 180 over the Orton Gillingham just because they are accomplishing the same result and there's no arguable reason why they would be different. But if a student was on Read 180 for a year and they made 10% of a year's progress, and then the parent took the student to an Orton Gillingham based program over 2 months and made a year and a half of progress, well, now we have a considerable difference. And that's something that I think most administrative judges would understand as a curriculum problem. And it's really not about the curriculum, it's about the needs of the student. The student needs a different way of learning. So if you're having a situation where you have that kind of experience, it's the proof that you have of attainability that sort of gets you into the door to have that discussion about curriculum. And then what kind of problems are we seeing as schools reopening? I wanted to bring up staffing. We're seeing a lot of problems getting staffing. In fact, when you read the news now, you're reading a lot about hard to fill positions at any kind of job. Schools are reaching out. In Poway, they recently asked families to tell people that they're hiring. So you're going to see aides that aren't available right now. We had an aide shortage before March of 2020. Now we're having a considerably different problem because it's much larger than it used to be. And that's going to dwarf a lot of concerns. So I just want to mention that if you're having these kind of problems, you don't have control of the staff for obvious reasons, but you do need to be documenting everything that's happening because you still have rights. Your child still should be getting the education that that IEP is planning for. So administrative decisions do not overcome students' needs is sort of a big takeaway from there. So I started out by saying we have a framework of, this is planning, procedure, and implementation. I just spent some time on planning, and we're going to jump into procedure for a minute. Procedures are rules that are put in place to protect the student and the IEP process. And when we look at a procedural violation, like let's say they have to hold a meeting within 30 days of a parent's written request, it's not just the missed meeting that meets that legal standard. And one of the reasons that some of the linguistics of this gets really confusing for families is that they will refer to a procedural violation as a denial of a FAPE in the LRE. But you heard me say earlier that a FAPE in the LRE refers to planning. So when we talk about procedure being a violation of FAPE in the least restrictive environment, we're actually talking about when the procedural problem rises to the level that we're going to treat it like it somehow interfered with the planning. And so how do we get there? Well, we have a rule that wasn't followed. We'll take that 30-day must hold a meeting. Maybe the parent wanted to talk about behaviors and they didn't have that opportunity. It didn't happen for 6 months. And when they met 6 months later, that team decided to do behavioral interventions for the first time. Well, if that's the case, that substantially impacted the parent's participation in planning 5 months earlier. It also impeded the student's right to receive their appropriate education in the least restrictive environment. And it also deprived them of benefits that were 5 months late. So we're looking for one of these three things. We're looking at a substantial impact on parents' participation at a meeting, or something that impeded the rights to the student to receive their appropriate education, or it somehow caused the actual deprivation of benefits. Not conducting assessments is another good example. The school district is supposed to assess for autism for a student who is suspected of having that, and they decide not to, or they don't feel like it's necessary because they've decided that the student doesn't appear to have autism. Well, in a situation like that, parent had the right to get that information about how it impacts the educational environment, attend a meeting and discuss it. And the failure to have that assessment for the parent, if you can show that they were required to do the assessment, means that they were substantially impacted in their participation in terms of developing that plan with that information. So not responding to requests for IEEs, failing to hold meetings, not discussing a distance learning plan with the parent, just sending it to them ahead of time and saying, here's what we're going to do versus, here's how we should do this with a family through an IEP meeting. All of those things can be procedural failures that impact the parent's ability to participate or impede that student's right to receive some appropriate services in their least restrictive environment, or actually deprive that student of educational benefit because they got something much later down the road that they should have had earlier.
And Seth, can I back you up for just a sec? So, I think that's such an important point to just think of, where the parents have, rights that they can be looking for, was my child, represented well or taken care of or not taken care of. And I'm curious, how much of the onus is on the school to identify that there is a challenge for the student versus the parent bringing it to the school's concern? Because I feel like that's something for us being in a private learning center environment. I get parents coming to me that say, well, I see my child struggling and I've seen it for years and I brought it up to teachers and they've said, oh, it's okay, or we'll wait and see, or, next year's teacher, it's the same story. And, parents at that point, they're coming to me privately and they've taken it upon themselves. And, I usually want to give them some feedback that, there may be some support that they could be pushing the schools for. But yeah, I'm just curious, if the school has not identified it and the parent hasn't overtly asked for an assessment, not knowing that that's their first step, what kind of follow through does the parent have at that point with the school, and is there like a liability on that sense for the school?
So there is a liability for a school district ignoring something. If we go back to a little bit of the earlier language, knew or should have known, it's the should have known piece that we're sort of talking about. And for a student that doesn't have an IEP, the school district has an affirmative obligation to seek out and find kids. We call that the child find obligation that might have a disability. Once we suspect that that exists, we have to essentially vet it out by doing assessments. That obligation to assess can be triggered by a parent's written request in California. In fact, the CDE has a regulation that says that a written request triggers those assessments, and a verbal request it triggers the school district or the agency to help that parent make that request in writing. So it's a very low bar once we suspect something. Even if the student's in a non-public school or a private school, the school district in which that private or non-public school is located in has a similar obligation to do that child find function, even if it's not the resident school district of the family. So, in regard to what they need to do, they need to be able to either see it or be told that it exists as sort of a way of simplifying that. Now, it gets really hard for, say, a student who's kind of holding it together at school. Maybe they're just kind of making it by, but when they get home, they're really struggling. That's where the school district could rightfully argue that they're not seeing these problems in school, but the parents are going to then need to bring that to the school's attention. The closer they are in academics to their grade level, and the harder it's going to be to see what those problems are. You might need a savvy teacher to be able to identify that that problem is occurring. So it's not always the easiest question to answer, but it's kind of a, we'll know it when we see it. And the school is obligated to seek out and find these kids that are struggling that way. But they are, given a little bit of leeway to figure out, who these kids are based on their performance, based on the areas they're struggling. So if a student was going to the nurse's office, 6 times a week, 7 times a week, and trying to escape work, that might be an indication that they needed some help, as an example.
Yeah. And, for a family, like you said, that raises that concern, but doesn't overtly ask for an assessment. I think that's an important clarification you said, where, the school is then obliged to help that parent process their concern as a formal written request for assessment.
Yeah. And one of the sort of more common problems is that a school district will say, let's hold a student study team meeting rather than do assessments. And the student study team meeting is not necessarily a bad thing, but the school district has 15 days from when they suspect a disability to give the parent an assessment plan. And if they use the SST meeting in order to have a discussion and then present the plan, that's fine. But if they want to kind of sit and wait and see, that's not fine. That's where the law still obligates them to look into special education. And that's true of a 504 plan where there's some assessment requirements as well. So, a 504 plan without assessments triggers an IEP assessment, or under the IDEA would trigger those assessments. An SST where they acknowledge ADHD, for instance, or maybe a student struggling with decoding, that would probably trigger the assessment process as well.
Okay, that is so helpful. Thank you.
No problem. So our framework is planning, procedure, and implementation. Planning is this idea that we're going to make reasonable decisions to plan, and that's what we're going to do. And the LRE is where we're going to do it. And we want to do it with, kids that don't have disabilities so that they have models, both behaviorally, academically, and so forth. And we really want to keep kids into the general ed as much as we can. Implementation is, now that we have this plan, how are we going to carry it out? And implementation's been real interesting with COVID because our original concern was a material failure. That's when things went wrong. And material failure is linguistic and hard to understand. So court cases have said a material failure is more than a slight deviation from the IEP. And that doesn't really help us much either, because what's more than a slight deviation? So I like to think about it as Monday morning, there's a speech and language pathologist, and the student's supposed to meet with him or her at 9 a.m. And it doesn't happen. The speech pathologist had a flat tire on the way to work, and that is not an opportunity to sue the school district. That's an opportunity to have a discussion and find out what happened. And they say, well, we had a flat tire. It's probably not going to happen again. That is not more than a slight deviation from the IEP. That is a sort of way of dealing with employment and the normal life things that come up. So when we look at more than a slight deviation, though, if it's happening, Monday morning, this child has a 9 a.m. session and it doesn't happen. 2 weeks passes, doesn't happen. 5 weeks passes. The speech pathologist wanders in at 1 o'clock in the afternoon and just keeps missing this Monday morning session. Turns out she really likes to have a bottle of wine, or he really likes to have his beer, gets up a little bit late and wanders into work. That is more than a slight deviation. That is something that school district or that agency should be addressing. This person's coming late and it's directly impacting that student. So that would be a material failure or more than a slight deviation. During distance learning, schools are required to implement the IEP to the greatest extent possible. And that language, again, we started out with a little bit of that language. It really does mean that they needed to carry out that IEP unless they had a really good reason not to. The language of a good faith effort was actually something that agencies had put out there, as long as we do a good faith effort. But that, didn't mean that they could cut services down in half because they're only doing half of the same instruction day. So you wouldn't want to reduce, your 1,800 minutes a year of speech to 900 just because the day got shorter. That wasn't what the law had intended. Greatest extent possible in cases has been a 20% reduction was a material failure for the purposes of the IDEA. So every situation is going to be different. If you had these kind of situations about implementation, or your son or daughter wasn't able to access the online program, that's really a situation where you want to talk to somebody about whether or not those rights were violated. So I just wanted to briefly talk about assessments, because when we talk about what we knew or should know, we're really talking about the information that the team has to make decisions. And assessments are 100% the foundation of all planning. It starts with the initial assessment, the referral that Megan was talking about earlier, that, did we find this child or did we assess them when the parent had made that request or when a doctor's note became evident about a disability? Once we suspected that disability, that was our initial trigger. Then every 3 years, the school district or agency is required to assess that student afresh. They need to see if things have changed. Of course, you have progress reports and teacher input and things along the way. But in my mind, the reason for the triennial is to sort of get that updated, clear picture of that student. So a common question parents ask me all the time is, should I go ahead and just do a records review for the triennial? Probably not. It's going to be very hard to compare a records review that looks at the previous records to those previous records and determine where your son or daughter is. Another trigger is the K-1 transition. When a school district or an agency is going to make a change in the placement that results in a reduction of services, the law wants to look at a transition assessment essentially and see if it makes sense to reduce those services because the kids are so young. The law also requires a assessment when warranted. When warranted is really a change of circumstances. An example would be removing services. Student met all their speech goals, so we're going to go ahead and remove their speech services. Well, that wouldn't be quite right. Just meeting the goal doesn't mean we don't have that need anymore. It might be a different need today, but it could still be a need. Another change in circumstance could be a rapid increase in academic levels or a rapid decrease in levels that we were not anticipating. So now we need new information. Why did that happen? Or maybe, is this accurate information? Once we decide whether we need an assessment, we have to look at the timelines. And the first timeline is from that time that we suspect either that change of circumstance or need for initial or the triennials coming up. We have to give the parent an assessment plan. They have 15 days to produce that assessment plan from that suspected disability or need. And we have 15 days for the parent to consider signing it and giving consent so that the school district can carry it out. Because without consent, the school district actually can't do their job. So generally speaking, if you're in agreement with the assessments, just go ahead and sign the assessment plan because you really need to get that started. And that's very important when we think about from that date it's signed, they have 60 days to produce a report after the testing and meet with the family and discuss those assessments. And you can imagine that if you're in November, that we're talking about 60 days, but we're also with holidays greater than 5 days, we're going to go ahead and suspend our counting and we're going to come back and start counting when we're back. Well, with the Thanksgiving and Christmas, you could easily find that your 2-month timeline looks a little bit more like 3 or 3.5. So it's always important to consider when you're signing these, but also to get this process moving. And there haven't been any waivers to these timelines due to COVID. We're finding a lot now in retrospect that schools didn't conduct assessments or put off meetings and triennials. And the problem, I think, doesn't necessarily come down to whether or not everybody agreed to wait. It's whether or not they picked the ball up and ran with it a little bit later down the road. And we're finding that some students are having IEPs that are 2 years old. So if that's a situation that you have, that's a good example. There were no waivers. They didn't get the option to just put everything on hold forever. So you should talk to your team about that or get some help. You should make all your requests, though, for assessments in writing or at an IEP meeting where you can go on record. And we always recommend that you record your IEP meetings. All you have to do is give written notice to the school district at least 24 hours in advance. So what about assessments that didn't happen during COVID? Well, they were still required to do it, with the only exception being at the very beginning of the pandemic. If there was no assessment plan provided between March and say, June of 2020, that would have been okay under California law. And that probably gives the school district or the school in this case, the option to sort of wait until the new semester begins to assess those children that didn't have something moving at that point in time. So can a parent request an IEE? So an IEE is an independent educational evaluation. The concept is that when a school district does an assessment that the parent disagrees with, that they can request that the school district fund an assessment by an outside provider that the parent chooses. And so the first piece of that is that there has to be an assessment that was done, or as part of an obligation to do a triennial, that they failed to do a specific assessment that they would have done, and therefore you're asking for the independent assessment to be done in its place. So an IEE is an independent, again, educational evaluation. It's a term you'll probably hear if you're involved in the special education sort of realm. And what the school's obligation to do is when a parent makes that written request for an IEE, they have essentially two choices. They can fund that assessment, give the parent information on how to carry it out, or they can actually file for due process, which is a hearing in special education, to prove that their assessment was good and that they don't have to provide the IEE or spend that money. And so those are the school district's two options: to fund the IE or to file for due process and show they did a good job. Now, the one little other caveat there is that they can't wait forever. So the law says that if there's an unreasonable delay, that they would have to fund it anyways. And the issue changes from whether or not their assessment was good to whether or not they waited too long. And that wait is typically 90 days in a lot of our cases, but it changes depending on whether or not you're interacting with the school district and they're discussing it, but there's delays happening. Maybe they want to conduct their own assessment before they answer you and they sort of wait on that. Well, they should have answered you. They should have told you what they were going to do. So you do have a right to request an IEE or an independent educational evaluation if you're not happy with the assessment that the school district has conducted. And just one little caveat to that, there are some dynamics to that. So if you think that you would like to get an IE, you should probably talk to an attorney or an advocate or somebody who can kind of walk you through the assessment, because it's not about the results of the assessment. It's actually about the content of it. Was it done correctly? Because two people can do the same assessment and come to somewhat different results. So we're looking at the professional judgment of the person based on the information they gathered, not necessarily the final outcome of that assessment. Again, deeper conversation, talk to somebody about it if you're not happy with an assessment, and get that a little bit of direction or an opinion on what you're looking at. So how do you handle concerns and disagreements? Before we get to our questions, I just want to give you a couple tips on good, solid ways to deal with this. Obviously, when you're in an IEP meeting, you may be surprised by information, or you may want to present something and not feel heard. So disagreements and concerns come up. That's normal. You want to audio record your IEP meetings. You want to give that 24 hours notice in advance in writing to the team. You can do that on the notice when you sign that you're going to come and attend. A written notice is an email, so you can send an email to somebody on the team, and then you can record the meeting. It's useful to go back and listen to and see if everything makes sense to you. It's also good to just make sure that everything you discuss wound up in the document so that it's clear to you. I always say ask questions and avoid demands. You're an information gatherer when you're at an IEP meeting. The school district maintains that obligation to carry out the IEP. And that's important to remember. So you want to let them follow through. You want to give them an opportunity to make that offer, because really you can't have a disagreement with something that they haven't finished. So you can disagree with parts as you go along and say, that doesn't make a lot of sense to me. Tell me a little bit more about that. But if you're just saying, I want more of this, let them get to the end and see where they come. And then you can say, I don't think that's enough time. Can you tell me why you think it is? And then you can get some help if you're kind of stuck there. But you always want to keep that meeting moving, because the obligation rests with the school district or the agency to produce an IEP and make an offer of a FAPE in the LRE. Make sure that you have copies of documents. This is especially true now that we're online. A lot of families have articulated that they haven't gotten their assessments prior to the IEP meeting. Normally, that's not a big deal. You're in the sense that you should have it at the IEP meeting, but now that you're not in person, we're finding that they were thrown up on the screen and the parents never even had a digital copy to sort of peruse through on their own time. So you want to make sure you have these copies. Be transparent with your information. If you have really good outside information, or maybe it's not that great, it's going to come up at some point. So if you have an academic assessment, an occupational therapy, a speech and language, consider giving that copy to the school district so that they're on notice of that information. Even knowing that you have a speech pathologist when they're not looking at speech is somewhat helpful for them to assess for speech. That would trigger, to some extent, their obligation. Now, on the other hand, if you don't give them that report, they can say, we didn't really see anything that triggered our sense that we needed to look into that. So be transparent with your information. Create a written record of what's happening. You probably have heard the idea that if it's in writing, it happened. If it's not in writing, it didn't. And that's true. School districts, local agencies, they create all the documents. They create your IEPs, the assessment plans, the notices of meetings. They fill out the protocols on their assessments. They write their assessment reports. They are in control of these documents. You are also in control of your emails and the letters and the things that you write. You're in control of recording that IEP meeting and making sure that there is a documented history of what's going on. And with that in mind, I want to share on our chat just a quick link to some record keeping tips that I think might be helpful for families. And then finally, I just want to mention prior written notice. If you get into a disagreement with the school district, you have some choices. And one of the choices that I think is advisable is to ask for prior written notice, which is a legal requirement for the school district to explain their position and why they're doing something or why they're not doing something. And that information is really helpful because then you can take it to somebody and ask if it makes sense. Is it reasonable? If it's about reading and they're looking at sort of present levels, you could take it to La Jolla Learning Works and say, does this make sense what they're saying about this curriculum? I don't know enough about it to answer that question. But what you really get to do when you do something like that is take the argument out of the IEP so that it doesn't interfere with the school district or school getting to that offer so that you can look and see where you're at the end of that meeting. So prior written notice is a wonderful tool for families. And with that note, I want to take us to the questions. I know that we have 8 questions. I think, Megan, you've been keeping track of which ones I may have answered.
Yeah, we do have a question in the chat that was just added. If you want to start with that one, I feel like it's kind of a good, general question around what to do when a child isn't making progress on their goals, and the school just kind of carries on. What would be the best step for a parent?
So I definitely think assessments are always a good starting point, but you do have to kind of look at when the last assessments were done. So if your son or daughter has had a triennial in the beginning of the school year and you're at the end of the school year and they haven't made progress on the goals, an early triennial might be too early. So what you might want to do is, have an IEP meeting and ask the team, what happened? Is it because the services are too low? Did we set the goals too high? What do we think happened? What's the reasonable conclusion here? Did we not carry out what we anticipated we were going to do? So this is a hard question because I've already pointed out 3 areas where progress on goals could potentially go wrong. Goals are too high. They didn't provide the services that they were supposed to, or the services were not sufficient. Those aren't easy questions to answer. And you can also have students that, to no fault of the school district, they struggled with their disability. A common one might be a student with epilepsy who has a seizure towards the end of the year. And unfortunately, they didn't retain a lot of the information. So the general rule of thumb is when the student isn't making progress on the goal, especially if it's up front and you're noticing this progress isn't happening at all, you want to call a meeting and have a discussion about that. You want to get some theories from the professionals on the IEP team about what they believe might be causing it. And to some extent, you might want to talk to some of your outside team, if you have one, about that specific area of need and try to get some insight that maybe isn't the school district, the people working with your son or daughter, so that you can sort of compare and contrast. Beyond that, you probably need to look at a bigger scope of records and maybe talk to an advocate or an attorney if you really feel this is an ongoing problem.
Thank you, Seth. Thinking of that idea of the child, just not making progress, and you were talking before about, having an outside assessment as something that might be the kind of initial step that could trigger the school's notice, that there is a problem with a student. Is that something that you recommend? And I'm asking this as somewhat of a self-serving question because, we do the private evaluations and I want them to be helpful for parents. Is that something, if a school hasn't provided services yet or acknowledged a need, that a parent can then, take one of our assessments to a school and say, hey, look, you told me, the last couple of years that things would get better, but look at how far behind my child is at this other assessment. What can you do for me?
Well, time is our worst enemy in life. So there's only so much time. And if you have the means and the ability to go out and have an independent assessment done through your own funding, I would recommend getting the information because it's going to be helpful, especially if in a situation like Megan's describing, the student or the parent has gone to the school and said, hey, I think there's a problem here. And instead of assessing, they said, hey, let's wait and see. At that point, there's a possibility that they didn't meet their child find obligation and that assessment might actually be reimbursable. But there's no guarantees on reimbursement. So, spending money has to be, to some extent at your own risk. But that information could be very instrumental in trying to sort of understand what's going on. Students with dyslexia who are struggling to read with decoding at certain grade levels, like first or second, you might start to see that initial sign, but they might still be struggling through and getting by. And the school might not sort of be in that sort of place to go and do that right away. They might think, all kids struggle like this. We see a lot of struggle. So yeah, the assessments are going to be very helpful. I would never tell a family not to go and get information that they have the ability to go and get.
Yeah, that makes sense. Thank you. I do have a question about where to start with a child who has ADHD. And we see a lot of families who have children with ADHD. So I'm very curious to hear what your response is to that.
Well, as somebody with ADHD, I have a lot of opinions on that. I think the starting point is, to let the school know you believe that's what's going on. There are tests within the psychoeducational evaluation that can look at things like executive functioning and attention. And I think the first thing is you have to identify what this is, where that struggle is. If we're talking about how to get supports for it, I think that is a little tricky with schools. A common goal, for instance, is, use of a graphic organizer. But the reality of it is when we're talking about executive functioning, probably a more pertinent goal would be to break things down into small steps and to be able to address these things. That might be included in a graphic organizer, but the goal in itself is not necessarily compensatory for that need. And so I think you really need to understand any disability, ADHD or otherwise, and how it's manifesting for that individual, because ADHD also does not manifest for all individuals the same way. And I think the other piece that you need to look at is sort of that behavioral aspect. Students with ADHD often exhibit behaviors. It's hard not to if you're not feeling good about your work, and maybe you're having trouble accessing it. So your attention is off somewhere else, and maybe you're interacting with other kids, and they're getting in trouble. So I think you really need to understand that individual student and how they're presenting themselves to figure out what that IEP is supposed to be doing for them. And it's important to identify, the pros and the cons, and specifically with that behavioral piece, because if a student's getting in trouble, you want to make sure that there's a record that this is their disability, that it's causing these problems, so that when those problems happen, that it's less disciplinary and more geared towards fixing the problem.
And for a student with ADHD, I think this, like you were saying, there's lots of different presentations, but could that student be eligible for, either a 504 or an IEP, depending on those circumstances, or are those just like 504 situations?
So it could be both. A 504 plan is for students that can access general education but need supports through accommodations and modifications. They're not the students that need goals per se. When a student qualifies for an IEP, which I'll go back to in just a moment, they get goals and services to address those specific goals, which is different from accommodations and modifications with both an IEP and a 504 plan actually have. The other thing is when a student is, say, out of school for more than 10 days, an IEP goes with that student because it's not necessarily tied to general education, and they're supposed to be able to continue to make progress on their goals in a different setting, whereas a 504 is intended for general education. So I often think of this idea of a calculator, a student who has processing deficits. In that particular situation, they might be extended time. That's an accommodation that would be fine. Maybe we reduce the work without modifying it so they can stay at grade level, but they're doing less and getting it done. But if we have a student that's, sort of looking at the numbers, doesn't understand what it is, they've got a calculator, which is an accommodation. They can match, so they do that. They match the symbols, they hit the equal sign, and they scribble out the answer, trace, if you will. Those students, you can't accommodate and modify. That 504 plan would not be appropriate for that student. And that's a pretty extreme example of sort of how it works, but I think it's a good indication of like how they're very different. The other place they're somewhat different is in their eligibility standard. For good reason, the 504 plan is broader. It captures more children. And so a student with an IEP would also probably qualify for a 504 plan or would qualify. But students with 504s don't always qualify for IEPs because you need to show two things. One, that they have this qualifying category. So it might be other health impaired or specific learning disability or autism. And just having a diagnosis, say, of autism doesn't get you into the educational category of autism. You also then have to show impact on the educational environment. The student is somehow struggling with the manifestations of their disability, and it's impeding their ability to access their academics or other parts of their educational day, including transition or behaviors with other students and so forth.
Got it. Thank you, Seth. Well, I know we're just about out of time today. I had a question though that I think might be helpful for parents, and you kind of touched on it here and there, like very indirectly, but mentioning advocates and special education attorneys. And while we're looking at this slide with questions and who to reach out to, can you give us just a little bit of clarification on when is it appropriate to reach out to an attorney and versus how can an advocate help?
Sure. So the reason I keep referring to advocates is because I'm a big fan of advocacy. Attorneys really aren't advocates in the same way that an advocate would be sort of a frontline person going to IEP meetings, helping you sort of understand documents and linguistics that are being used, maybe that you haven't been introduced to. Maybe it's an emotional experience for you, and an advocate is somebody who can distance themselves from that and have discussions with the IEP team. And sometimes they can resolve disputes behind the scenes, and some do, and that can be very helpful because you can avoid having to see me altogether. Um, so, but a special education attorney is really somebody who deals with a dispute, whether it's a dispute over what the plan is or a dispute about something that's happened in the past. We're helping resolve those problems. And often those lines cross, which is one of the reasons that there's some hesitation in my voice. So sometimes people will come to us to figure out where they're at or which one they need. That's not uncommon. A lot of things look like they might be legal issues. They feel like violations. They feel very emotional. But often, in following the legal process, a lot of schools wind up doing things that don't make common sense logic to a lot of families. It might seem like they're taking too long, but the law provides a specific timeline that may be legally appropriate. It just doesn't feel good. So if a family has a question about which direction to go, it's often okay to start with an attorney and let the attorney say, I just don't see that case, but I would recommend either talking to another attorney or going to an advocate. In fact, we make quite a few referrals. We have a good sort of pulse on who's out there, and there are a lot of just really wonderful advocates. In the last 5 or 10 years, that number has jumped up, and there's people that have left speech and language jobs at school districts to become advocates. There's at least one special ed director who's done that. And then there are parents who have just gone through this experience and really want to share that knowledge forward. It's not it's not particularly a regulated industry, so you should go and talk to the people about what their experiences are and make sure that they're a good fit for you on a personality level. You're going to work with an advocate for much longer than you work with an attorney. Attorney will work on your case, and when it's done, it's actually done. But your IEP process could be from 3 years old all the way to 22. So an advocate relationship is a very meaningful one, and I would highly recommend families even just to look into it to see if it makes sense for them.
Thank you. That really gives a lot of clarification on it. So I know we're at the end of our time. I feel like we could talk all night. There's so many questions, but I think this is so helpful, and I appreciate you sharing with everybody that they can just reach out to you with questions, because I think a lot of things, like you said, are case specific, and it's really about hearing where somebody is with their child, with the school, and being able to tease out if it is a legal issue or if it's something more to go down the route of advocacy. And we just really appreciate you to be there as a resource for them.
I appreciate that, and I appreciate you guys for being such a great resource. So many families have come to you and been very happy with the results and the assessments that you've done. So thank you for doing what you guys do.
Thank you so much. Well, thanks to everyone for joining us. And Seth, we really appreciate your time tonight. And we will be sharing this out with our audience. And I know they can reach out to you either at email or phone, and definitely check out your website to see what kind of resources you have out there. And we'll pass along the link that you shared too with the resources for parents as well. So
Thank you very much for having me.
you're welcome. Take care, everyone.